Welcome to Legal Minds. Battery, just like a technical assault, comes under Section 39 of the Criminal Justice Act 1967. For committing a battery, you can receive an unlimited fine and/or up to 6 months imprisonment, again, just like with a technical assault. A battery involves the infliction of unlawful personal violence by the defendant upon the victim. But what kind of violence is needed? Because when we think of violence, we think of maybe extreme violence, or maybe something that's not so extreme, but maybe something like a punch or a slap. Well, that can amount to battery, but Lord Lane in Collins and Wilcock, with reference to William Blackstone, said that any touching, however slight, may amount to battery. Therefore, you do not need to physically attack somebody in the strict sense, in the way that we think of when we think of violence. You don't need to punch somebody in the face. You don't need to slap them. You don't need to kick them. You don't need to actually apply that kind of force. A slight push may be sufficient for a battery. In the case of Day, the court held that even touching a victim's clothes can amount to a battery, and this applies even if the victim doesn't realize you're touching their clothes. So this can also be seen in the case of Crown against Thomas, where the defendant touched the hem of the skirt of the victim, and that amounted to a battery. So there doesn't necessarily have to be skin-to-skin contact. There doesn't have to be any force felt by the victim. Touching their clothes can be sufficient. In DPP and Smith, cutting the victim's hair amounted to a battery. Although you may not think it would amount to a battery, the court felt that our hair is integral to our identity, and therefore it amounted to a battery. And when you think of a battery, it sounds like hostility is required. You hear the word battery, it sounds like you actually need to batter somebody, or you need to intend to batter them, but that's not actually the case. In the case of Fauntler and Talbot, it was held that hostility is not a requirement. However, later cases such as Wilson and Pringle kind of led to some confusion, where those cases held that hostility was a requirement. However, you need to remember that Wilson and Pringle is a civil case, and later criminal cases such as Brown confirm that hostility is not a requirement. Not in the strict sense anyway, because the court in Brown said that as long as an act is unlawful, then it amounts to hostility. Now, of course, in actual English language, hostility doesn't mean unlawful. Hostile doesn't, if you're breaking the law, that doesn't necessarily mean you're hostile. But the court seemed to be of the view that if an act is unlawful, it's hostile. So hostility in the strict sense is not required for a battery. The question is, how can a battery be committed? Well, there are various ways it can be committed. You could just go up to somebody and physically attack them, but you can also commit a battery through a continuing act, and this is what happened in the case of Fagan. In Fagan, the defendant drove onto a policeman's foot by accident. Of course, the policeman then started shouting, "You're on my foot, you're on my foot," and the defendant, after realizing he was on the policeman's foot, refused to move his car for some period of time. And the court held that amounted to a continuing act. It was really a positive act, it wasn't an omission. However, in the case of Miller, it was said that where the defendant creates a dangerous situation, he's under a duty to take reasonable steps to rectify it. In the case of Miller, a squatter he lit a cigarette, and he was smoking a cigarette while he was squatting. So he was in an abandoned building, and he fell asleep in this building with the cigarette lit. And when he woke up, there was the mattress he was sleeping on was smoldering. It was going to catch fire. Instead of doing anything about it, he just left and went to another room, and the mattress caught fire, and quite a bit of damage was done to the building. Now, the court here took a different view to what was taken in Fagan. They didn't think it was a continuing act. They thought it was an omission. And the change came about because Lord Bridge felt that the duty to act theory was easier to explain to the jury rather than the continuing act theory. And I think I agree with this as well. It's much easier to understand the concept of a failure to act upon your duty rather than a continuing act, which is somewhat passive, like it was in Fagan. And according to Alan Reid, if a situation like Fagan was to come before the court today, it would likely be deemed to be an omission. And this view is generally being accepted, and this is a view that I personally agree with as well.
And now we should move on to the topic of indirect battery. The first case that deals with this would be Martin. In this case, the defendant shouted "Fire!" in a lecture theatre. As one can imagine, this caused much disruption, which also led to several people being crushed and injured. Hasted is another case whereby a defendant punched the victim who dropped her baby. The court held the defendant liable for the battery to the victim, and this issue has been linked very closely to the topic of transferred malice. Another case that links with indirect batteries would be the case of DPP and K. This involved a mischievous schoolchild who had been excused to the boys' toilet, hiding and concealing the acids inside the dryer on suspicions of being caught by a teacher. Unfortunately for another student, they were injured when they used the dryer, and this was held by the court that indirect force is enough to result in an indirect battery. With indirect applications of force, you still have to establish causation. The key case that gives us authority on causation in relation to indirect battery would be the case of Roberts, whereby a victim jumped from a car thinking that a male was trying to sexually assault her. And the court held, although indirect application of force acts caused the injury suffered. So the mens rea of battery is the intention or recklessness to apply force to the body of another. Recklessness used to be an objective test as shown by DPP and K. It did not matter back then that the defendant was a child. However, in Venner, the court approved of the Cunningham-style recklessness approach. Therefore, the mens rea is the intention or subjective recklessness to apply force to another.